Legal systems. In general, legal systems can be split between civil law and common law systems. The term civil law referring to a legal system should not be confused with civil law as a group of legal subjects distinct from criminal or public law. Civil law is the legal system used in most countries around the world today. In civil law, the sources recognized as authoritative are primarily codified legislations or statutes. Historically, civil law codifications were based solely on Roman law, alongside some influences from religious laws such as canon law that are continued to spread throughout the Europe. In the 19th century, both France and Germany modernized their legal codes. Both these codes influenced heavily the legal systems of the countries in the continental Europe. Today, the countries that have civil law systems range from Russia and China to most of Central and Latin America. Except Louisiana's civil code, the United States follows the common law system. In a civil law system, the judge's role is to establish the facts of the case and to apply the provisions of the applicable code. Though the judges often bring the formal charges, investigates the matter, and decides on the case, he or she works within a framework established by a comprehensive, codified set of laws. The judge's decision is consequently less crucial in shaping civil law than the decisions of legislators and legal scholars who draft and interpret codes. In common law legal system, decisions by the courts are explicitly acknowledged as law, on equal footing with statutes adopted through the legislative process and with regulations issued by the executive branch. The doctrine of precedent or stare decisis means that the decisions by higher court bind the lower courts and future decisions of the same court to assure that similar cases reach similar results. In contrast, in civil law systems, legislative statutes are typically more detailed and judicial decisions are shorter and less detailed, because the judge or the barrister is only writing to decide a single case rather than to set out reasoning that will guide future courts. Common law originated from England and has been inherited by almost every country once tied to the British Empire. The concept of common law developed during the reign of Henry II during the late 1100s, when Henry appointed the judges that had authority to create an institutionalized and unified system of law common to the country. The next major step in the evolution of the common law came when King John was forced by his barons to sign a document limiting his authority to pass laws. His Great Charter or Magna Carta of 1215 also required that the king's entourage of judges hold their courts and judgments at a certain place, rather than dispensing autocratic justice in unpredictable places about the country. However, the system became overly rigid and inflexible. As a result, the increasing number of citizens petitioned to the king to override the common law, and on the king's behalf, the Lord Chancellor gave judgment to do what was equitable in a case. As a result, a systematic body of the equity rules grew alongside the rigid common law and developed its own court of chancery. At first, equity was often criticized as being inconsistent. Over time, courts of equity developed solid principles that are more consistent. Later on in England, the two systems were merged. One of the differences between the common law and the civil law system is their approach to legal proceedings. In a civil law system, the court is actively involved in investigating the facts of the case. This kind of system is called an inquisitorial system. On the other hand, in an adversarial system, the role of the court is of an impartial referee between the claimant and the defendant. Adversarial systems are used in countries with common law systems as opposed to civil legal systems. Countries using the common law, including the United States, may use an inquisitorial system for summary hearings in the case of misdemeanors such as minor traffic violations. At this point, if you want to learn about the categories of English law, you can see Lecture 2 and 3 in Section 1 of Criminal Law.